you don't win your appeal hearing with the referee, then your next option is to file an appeal with the Board of Review. The Board of Review is a group of 3 people appointed by the governor to review decisions appealed from the referees. You must file an appeal to the board within 11 days of the referee's decision being mailed to you. So pay attention to the dates and deadlines found on the referee's written decision. It's important to understand that an appeal to the Board of Review is very different from your first appeal. The board doesn't accept any new evidence and rarely holds a hearing. In fact, an employee in the appeals office once told me that they've only seen 1 hearing take place in about 7 years. An appeal to the board is just a written letter or document that explains why you disagree with the referee's decision. Because it's a written appeal, and because you can't present new evidence, this appeal is more like a legal brief than anything else. It needs to explain exactly what the referee got wrong based on the facts of your case and the law that applies to it. It might even ideally include some citations to the unemployment statute and regulations and court cases that interpret those cases. So your chances of having the board reverse the referee's decision aren't great. In fact, the law says that if the referee affirmed Dieter's decision to deny you benefits, then the board can choose not to review your appeal. So for example, if Dieter determined that you are not eligible for benefits because you voluntarily quit without good cause, and the referee draws the same conclusion and affirms the first decision, then the board can decline to review your appeal at all. On the other hand, if Dieter determines you're eligible and then your employer appeals and the referee reverses Dieter's decision, then the board would be required to review your appeal and issue a written decision. In my opinion, if you hire an attorney to write an appeal letter to the board, if you can afford it, then your chances of having the board look at it are probably better. But I honestly can't say for sure because I'm not on the board. Also, in my experience, most people aren't very capable of writing a strong appeal simply because they're not trained lawyers and are not sure what to focus on or how to discuss the law that applies. That said, there's no reason you can't write an appeal yourself and do the best you can with it. Follow the instructions in the referee's decision on how to submit the appeal. According to the Nevada Supreme Court, the board needs substantial evidence to overturn the referee's decision. This means the bar is pretty high, so whether you submit an appeal yourself or have an attorney, your chances aren't great either way. But if you can identify some clear error the referee made, then your chances are better. If you choose to file your own appeal, you'll want to point out the specific evidence that supports your appeal by referring to the exhibit numbers in the appeals packet and other evidence that was admitted into the record. The board should have all that evidence, but if there's a really important piece of evidence, then I definitely recommend attaching it to your appeal when you submit it to the board. You can also refer to testimony you or other witnesses provided during the hearing. Again, stay focused on the specific reasons the referee mentioned for denying you benefits and provide arguments and evidence to show that those reasons are incorrect. Try not to get distracted by tangential arguments and evidence that aren't as important. After you submit your appeal, the board will eventually either send you a letter saying it has declined to consider your case at all, or it will issue a written decision. The decision could either reverse the referee's decision or affirm it. Another possibility is the board could remand your case back to the referee to get more evidence and or redo the hearing if they think something important is missing. This doesn't happen very often, but it does happen sometimes. I like to include a sentence at the end of my appeals asking the board to remand the case back to the referee to take more evidence if it doesn't think the record is complete enough. Also, some referees tend to be sticklers during the hearing and maybe even rude, so if you don't think you were given a fair opportunity to present your case, including any important evidence, then you could also raise those concerns in your appeal by saying you didn't receive due process. If the Board of Review declines to consider your case or affirms the referee's decision, then your final option is to appeal to the district court.